Recent judgments in two major cases, Mejprom and Pugachev and Zhang Hongli and DBS Hong Kong Limited, have had significant and wide-reaching implications for the offshore trust industry and are key to the evolution of modern trust management and administration. More information on each of these cases is available via the link below. In this video excerpt from the Southpac Offshore Planning Institute, which took place in Nevis in May 2019, Southpac's General Counsel Vibha Vallabh gives an overview of a new structure developed by Southpac, the Foundation Trust Structure. This allows persons wishing to set up an asset protection structure a greater degree of control while minimising risk if the structure is attacked. Please don't forget to like, comment and follow to stay up to date with Southpac.
The trust deed should state the protector's powers as being fiduciary and then not personal, especially if the client is the settlor beneficiary and also wants to be the protector. Before onboarding a client, if it appears that a settlor has too much control to an extent that the trust assets could revert back to them, then there must be a warning notice given to them before they establish the trust. So, these recommendations that the trustee should start implementing, but I can appreciate that there will be some clients that won't be happy with these provisions because they do want that level of control. But at the same time, there's now this duty on the trustees to have to implement a high level of supervisory role. So with that in mind, we have come up with a new way forward. So this allows the settlor to have their cake and eat it too. The trustee does not need to rely on the supposed protections of anti-Bartlett provisions. There's no, we can limit the fiduciary duties onto the trustee as well as perhaps the corporate director and nominee director, and also this new structure will provide a level of asset protection. So with reading those case law in mind, Southpac have now come up with this new structure, which we've all sold already to a number of clients. And, it allows the client to have a level of control, and it also minimises the trustees' high supervisory role obligations now. So at the top we've got a foundation, and I recommend a Nevis foundation simply because they're more flexible and they provide the asset protection provisions similar to a trust that you wouldn't find in other jurisdictions such as Liechtenstein, the Dutch Stichting, and foundations coming out of Curacao and in Germany. So the difference between a Nevis foundation and those other jurisdictions is that they provide asset protection provisions similar to a trust. So, a foundation is a hybrid between a trust and a corporate entity. A foundation can have purposes as well as it can have beneficiaries. But in having beneficiaries, the beneficiaries don't have beneficial interest or rights as it would underneath a trust. So there is no actually any fiduciary duties at this level because there are no shareholders that you need to be answerable to or any beneficial interests that the trustee needs to look after. So basically the foundation just owns itself and runs itself. But with the foundation structure, you would have the client as the member, so they can be themselves as the sole supervisory board member, as a management board member, or they can have a group of board members. The foundation can have purposes, and also it can have beneficiaries. So in this instance, where you want to have some asset protection, you would have perhaps the founder and their family members as beneficiaries, but you would also add a Cook Islands Trust as a beneficiary. So you allow the client to manage their entity, so it's no longer in an LLC that we would see in the traditional structure, the management of the assets occur at the foundation level. And they can manage all the assets how they want and not be answerable to anyone, and they don't need to, there's no supervisory role required by the trustee, and there's no fiduciary duties owed to any shareholders because there is none. But in order to, the client who is the management member in managing the foundation, they're going to expose themselves to litigation potentially in their own country because, particularly in the US, you get litigated for anything. So that, there's a high risk of that, and they might not necessarily recognise a foundation. So what we would recommend is that the active part of the assets remain in the foundation, and you use the trust as like an insurance policy or a bank account. So they move, the assets move from it being active into passive, and you place the passive assets into the trust. And so at this level, the assets do not require too much of the trustee's participation because they're just sitting in the trust like a bank account essentially. And if there is any problem with the founder or the member, facing litigation, then you basically, the assets are safe in the trust, and the management board can actually remove the Cook Islands Trust as a beneficiary of the foundation. So effectively, the top part of that structure, the foundation part, I would say it's like a fishing boat. It collects all the fish, and then it places into the trust as a fishing net. And any sign of any problem, it can cut off this trust and it can float on its own, and you've still got some asset protection there. So the trustee steps in, and it's going to manage the assets anyway, but those assets are free. The passive assets placed into the trust, the trustee can still make distributions to the beneficiaries within that trust. So I think this new structure, if from that list that I read out, if the client is unwilling to go down that road and they still want their cake and eat it, but the trustee is not willing to take on that level of risk, if the client is unhappy for the trustee to have this high level of supervisory role, then this is the next best alternative. Otherwise, what we're going to see throughout the industry is that the trustee is going to have this high supervisory role, and that's going to mean the trustee being more active, and it needs to be more active to know what's happening within the structure.